And we can begin.
Good afternoon, everybody. My name is Richard Haggerty. I am the CEO of the Hudson Gateway Association of Realtors, and I am so happy to have you all join us for this special program, a legal and legislative update for our members in the Bronx and Manhattan. And I am sure you're going to find this very, very informative. First, I would like to introduce the president of the Hudson Gateway Association of Realtors for this year, who is actually raised in the Bronx. Crystal, if you could give us a few introductory remarks, we would appreciate it.
Well, thank you so much, Richard, and welcome everyone. I'm so excited to know that we have over 100 of you have registered to be a part of this event. And yes, I am a Bronx girl, originally from the Fordham section, and I have many family members that still currently live in Manhattan and Upper Manhattan. So I think it's very important to know that you are a part of our new family here at the Hudson Gateway Association of Realtors. You're a strategic location and you are important partners for us as together we build the American promise. With that said, events like this is very important in helping us to be educated and at the top of our game in terms of our industry. So without further ado, I'll turn it back over to our CEO, Richard Haggerty.
Thank you so much, Crystal. We really appreciate those remarks. I'd like to introduce now Brian Phillips, and I want to really give Brian credit for coming up with this idea, and we really appreciate all that he did to bring this whole program together. Brian has been an associate broker with Douglas Elliman Real Estate for the last 14 years and is duly licensed in both the Harlem and the Bronx Riverdale offices. He's best known for his moniker, the Mobile Real Broker, and he and his team cover several counties, including Manhattan, Brooklyn, Bronx, and Westchester. Brian is self-driven, tech-savvy, and is a real estate professional having 24 years of sale and leasing experience. Brian is an HDR Board of Directors member and serves on the several committees for the Real Estate Board of New York. Brian, again, thank you so much for bringing us all here today. This, again, was your idea, and I'll let you take over some of the other introductions.
Thank you so much, Richard. Thank you so much, Crystal. First up, our first guest speaker is attorney Eliza Rodriguez, who's a former CEO of the Bronx Manhattan North Association of Realtors. Following the merger with HJR and Bronx Manhattan NAR, Ellie is now HJR Director of Advocacy, Commercial and Legislative Issues for Bronx and Manhattan. Next is attorney Brian Levine. Brian is an HJR in-house Counsel Director of Legal Services and Professional Standards Administrator. Last but not least, Mike Kelly, New York State Association of Realtors Government Affairs Director. Gentlemen.
Brian, I think we're going to have Brian Levine take it off with the legal update to begin with. So Brian, please give us a
morning. Good morning, everybody. I have been told I only have a short amount of time and we have a lot to cover. Obviously, you realize that a lot has happened in the last year. So we're going to jump right into this. I'm going to share my screen. And we're going to start. So.
And Brian, if I could chime in as you're sharing your screen, for those of you who have questions, if you could please type your questions in the question and answer panel. And by the end of Brian's presentation, we will address as many questions as we can.
And let's see. Here we go. Fingers crossed, technology should be working for us. And I don't see anything on my screen.
Is it asking you to duplicate slides at the top, possibly? Duplicate screens?
No. Hang on. Stop sharing. Now let's try this again. So Seeing that I'm having some problems with this, Gary, I sent you the slides. Could you run the slideshow for me?
Absolutely. One moment, please.
Thank you.
So Brian, why don't you begin, and then Gary will catch up with the slides.
Sure. Okay, so a lot has happened since 2020. What's most important is obviously COVID. So the COVID state of emergency took place about a year ago, and it is still in effect at this point in time. We are still in a state of emergency. That state of emergency is going to stay in effect until March 24th, although it'll probably be renewed. As a result of the state of emergency, there is no cold calling. What does that mean? That means simply that agents are prohibited from making a cold call to prospective clients with whom they don't have an established relationship. So you cannot call a FSBO. You cannot call an expired to solicit their listing. But you can call a FSBO if you have an identifiable purchaser who's interested in the property. So you would have a buyer that might be interested in purchasing. You can reach out to that FSBO to make those inquiries. You can still continue to market by doing mailings, but NYSAR has indicated that they're recommending against door knocking and door hangers. And the reasoning is this. Phase 2 noted that all real estate activities must be conducted virtually to the fullest extent possible. Going on doors, knocking at doors is not the best and most contactless way available. So they believe that such activities are not permissible. If you feel compelled to do so, you do so at your own risk. That was NYSAR's opinion on that. So next slide, Gary. What just came out recently, literally this month, is the notice of closing for notice disclosing tenants' rights to reasonable accommodations for persons with disabilities. This came out on March 2nd. What it requires that every housing provider is to provide a written disclosure to all tenants and prospective tenants. This notice has to be provided within 30 days of the tenancy, or for current clients within 30 days of the law going into effect. Now there's an issue as to the definition of when this triggers. This 30 days is requiring clarity. Does it take place before or after taking possession? NYSAR and HGAR are of the opinion that they have to provide this disclosure prior to taking possession, as it would only seem to make sense. But there's still this question of doubt. It must be conspicuously posted on all vacant properties. So if the property is occupied, you don't have to post it. But if it is empty, it must be posted. We don't know yet, and hopefully we're going to find out what the proper conspicuous posting is. So the Division of Human Rights, DHR, they haven't provided guidance on how to post this, but we suggest that you post it somewhere in a conspicuous fashion. They most recently, the DHR just recently came up with sample language to utilize, but they don't have a standardized form just yet. So you can go to the website. It's https dhr.gov/required notice, and you can see that language. You can pick it, cut it, paste it, put it on your own form, co-brand it if you find necessary. But it's important that you get this out to your clients so they can begin posting it. This is in effect, so we need to stay in compliance. Just as a side note, NYSAR is seeking clarification on the 30-day notice as well as the posting language. Next slide, Gary. So COVID forms. Since 2020, we've had a lot of questions about COVID forms. Unlike our disclosure forms, our 443 disclosure forms, and our fair housing disclosure forms, COVID forms are not mandatory. They are done at the discretion of your client. If you have a discussion with your clients and they deem that it is in their best interest to have a COVID form, then you can supply the COVID form. Remember, it's your client's decision, not the brokerage's decision. Now, if a brokerage insists on having these COVID forms supplied, then they can have a conversation with that client. And if the client isn't in agreement with this, then there would have to be a disassociation between you and your client. So the two forms are very simple. There is the COVID disclosure form, which is quite simply, it makes the party aware of the risks of people coming into their properties. And then there is the COVID questionnaire, which is a series of questions about the exposure from the parties. And this can be from a landlord or a tenant or a buyer or a homeowner to fill out these forms. And I believe these are on the NYSAR website, and these can be co-branded. So next slide, Gary. Advertising regulations went into effect in November 2nd of 2020. Next slide, please. These websites, with regard to advertising on websites, they came up with some new language. All brokers and agents that advertise an exclusive listing of another broker must now clearly and conspicuously display the names of the listing broker preceded by one of the 7 permitted terms. Now, first of all, clearly and conspicuously means, as Anthony Gatta loves to say, above the fold. That means that it needs to be near the listing itself. You shouldn't be scrolling down to find the information. So it has to be up near the top. So what are the choice of words? They are listing provided by, listing broker contact, listing of, listing provided courtesy of, and listing agent contact. Those are the only terms that are permitted. You cannot make up your own terms, and you have to use these terms. Next slide, Gary. This includes utilization on IDX feeds on anybody's website. So that means you're responsible for making sure that these feeds go out and they have this provided language in place. If it is an advertisement and it's paid through to a third party, it must state advertisement immediately after the licensee's name. So as I said before, agents and brokers are responsible and liable for any kind of feeds to third parties. So make sure all these terms are in place. Next slide, please. So license renewals. This is a trigger moment. We have to look at July 1st, 2021. Everybody's license renews at a different time. So make sure that you find out when your license is going to renew. So timing's everything. Next slide, Gary. If your license renews before January 1, remember, before January 1, you have to complete 22.5 hours of continuing CE. Of those 22.5 hours, 3 hours has to be fair housing, 1 hour has to be agency. Unless you're a new agent, then you have to supply 2 hours. If you are grandfathered, if you're one of the people that does not require CEs because you've been doing it for so long that you feel you don't need CEs and the state doesn't require you to do CEs, you are still okay. However, next slide, Gary. If you renew on January 2nd, you have new guidelines to follow. Number 1, there is no more grandfathering. So all you people that have not been required to take CE courses now must get your CEs. Keep this in mind because you will still have 22.5 hours of CE training. If you make a mistake, you're going to spend an entire day taking CE credits. So make sure that you get them done in advance. So check your dates. After July 1st, you have 22.5 hours of CE credits. And of those, you will have to take 3 hours of fair housing, 1 hour of agency, 2 hours if you're a new licensee, and 2.5 hours of ethical business practices. This includes the NAR Code of Ethics training. And one last thing you'll have to take is the 1 hour of recent legal matters. This is subject matter that will be discussed by an attorney and includes statutes, laws, regulations, rules, codes, DOS opinions, decisions, a variety of matters. So in addition to these new regulations after January 1st, please keep in mind that you also have to satisfy your NAR Code of Ethics. It was every 2 years. It got changed to every 3 years, and they extended the cycle to the end of this year, 12/31/21. So you're required to have 2.5 hours of Code of Ethics training by the end of this year. Okay. Fair housing, as we are all aware, fair housing is the forefront of everybody's mind. Fair housing went into effect on 6/20 of last year. And there are two things. Number one, you must provide a housing and anti-discrimination disclosure form to every consumer at first substantive contact. Remember, this is exactly like your 443 agency disclosure form. If you have contact with somebody outside of property, you provide it then. If you have contact with someone through an email, you provide it then. If it's over the phone, you get that contact information and you provide it at first substantive contact. In addition to that, we also have to post a housing and anti-discrimination notice. This is a notification that has to be posted at all offices and all open houses. It also has to be posted on your website, or a link to it needs to be posted on your website. Second to last thing we're going to discuss, clear cooperation. May of 2020, One Key MLS's Board of Managers clarified clear cooperation. It states that within 1 business day of marketing a property to the public, the listing broker must submit the listing to the MLS. This is 1 business day. So if there's a holiday, you have a grace period. If there's a Saturday or a Sunday, you have a grace period. So it's the 1 business day rule. What does it require? Next slide, Gary. It requires that all residential property classes are subject to this rule, including the following: 1 to 4 family homes, but not residential properties with 5 or more units. Residential cooperative buildings, condominiums, units in an HOA, townhomes, and even mobile homes. Residential rentals, and even vacant land that is zoned only for commercial use. Again, commercial, non-residential properties with 5 or more units are not subject to this rule. So the next question you should be asking yourself is, well, what is marketing to the public? Marketing to the public includes flyer displays in windows, yard signs, postings at your church or synagogue, digital marketing on public-facing websites, brokerage website displays, including IDX, digital communications such as email blasts, multi-brokerage listing sharings networks, and applications available to the general public. If you send this out, if you send out information, you have to post it on the MLS within 1 business day. Now, clear cooperation should not be confused with coming soon. Coming soon is a tool in our MLS that allows a homeowner to kind of preview their property, to kind of stir up some buzz in the community. This went into effect mid-2020, and the purpose of coming soon, no showing status, is to allow a short period of time in order to prepare the property for showings, after which time the listing will become fully active and available for showings. Selling and listing brokers may not show, promote, market, or advertise the property in any manner other than what is provided by this rule. So, coming soon will be displayed on our MLS, including our IDX and VOX websites and mobile apps, but it's not going to be syndicated to any third properties. So you as members get a little bit of an edge on the coming soons. Additionally, the property may be marketed as follows. You can place a sign on the property that states coming soon. You can send out printed flyers stating coming soon with the date in which it goes on the market. And you can even send it out by email to the listing broker's current clients, customers, stating that coming soon will be coming on the market on a specific date. Keep in mind, to do a coming soon, the owner has to provide specific written instructions which permits this to take place. The coming soon property is entitled to this status for a maximum of 14 days. And after 14 days, what happens is it automatically flips to active. If for whatever reason you're not ready to have it go active, the agent can go in and they can take the property and place it temporarily off the market. But what's important to understand is that while the status is coming soon, it cannot be shown to anybody, or as they like to say in the industry, no one can cross the threshold. So I believe that covers everything, and I think I may have gotten it in under 20 minutes. Any questions?
Okay, we have some questions in the chat, but I have a few questions on behalf of my colleagues with regard to fair housing and housing vouchers, if I may.
Sure.
Okay. How do agents vet customers with housing vouchers? For instance, can agents ask customers what their credit score is or whether they have a current landlord reference? And can a tenant agent share this information with exclusive agents, management companies, and landlords?
Sure, it's a good question. You can ask, agents can ask customers for their credit score. There's a slight caveat to this though. Credit scores are a great thing to utilize to vet potential tenants. But the challenge becomes if they have a voucher. Let's say for instance, they have a Section 8 voucher, and the voucher provides for full payment of a rental. Under that provision, asking for a credit score makes no sense. So NYSAR has come up with the opinion that asking for a credit score for somebody that has a full rental being covered by Section 8 isn't a valid request. It isn't a valid question because the government has perfect credit. They have a perfect credit score. So it's irrelevant whether a consumer or a tenant is being asked for a valid credit because the government's paying for it. If there is a program where the tenant is paying for a portion of it, then a credit score becomes applicable. You follow me?
And can we share that information with exclusive agents?
That information can be shared. I would always caution people from sharing credit scores. If credit reports are done, I always recommend that the agents kind of remove themselves from the process. That's something that should be provided from the tenant to the landlord because of privacy concerns. So the more you can remove yourself from that situation, the more you prevent yourself from falling into any kind of liability.
Mm-hmm. Another question is, when setting appointments, are tenant agents allowed or even obligated to volunteer to exclusive agents, management companies, and landlords that the customer they're bringing has a housing voucher?
There's no requirement that I'm aware of by law that indicates that you've got to share someone's financial situation when setting up a showing. As we all know, source of income is a protected class. You're not required to divulge that information at the first stage, but at some point in time, you're going to have to disclose this information to the landlord because they're going to ask credit scores, background checks, source of income. All these questions are valid questions to ask. So I believe in the concept of transparency. I know this might be concern with landlords not wanting government subsidized tenants. I don't understand that, but I mean, it's up to this discretion. You should have that conversation with your client if and when you want to disclose that information.
Okay, are landlords and management agents, management companies rather, entitled to a background check with customers on housing vouchers?
Yep, background checks are still permissible. Under the new rent regulations, they can charge $20 for the actual cost of the background check, whichever is less. That is $20 per applicant. And if the applicant has already had a background check within the last 30 days, the landlord has to accept that prior background check as sufficient and not charge them for another background check.
Can landlords insist on a specific credit score?
They can, but again, it falls back on my last conversation of, is a credit score relevant? If someone is having their rent covered completely by a government subsidy or a government program, credit score is irrelevant because the government has perfect credit.
Okay. When a housing voucher does not cover the full rent and the tenant has to pay a difference, does the landlord have to accept the voucher?
What you have to do as a realtor is have a conversation with your clients. What's important is you have to look at the program. Does the program permit partial coverage of the voucher or whatever the program is and allow for the tenant to subsidize that amount? Quite often, I believe, and I don't do a lot of Section 8 work, but I believe under Section 8, if they're offering a voucher for Section 8, that's the highest amount that they can get, and they're not permitted to subsidize those amounts.
Okay. We have a few questions in the chat. Richard, do you want to take those on?
We have one that says, for commercial brokers, is it enough to have the anti-discrimination language on your email signature?
No, you actually have to have a link to the fair housing document itself. That actually has to be a link. It has to be conspicuous.
And I think that Brian's questions covered the other ones that are in the chat, if I am reading these correctly.
I'll also throw in one more update, and this has been coming across my desk quite often, is there was back in early 2020, before COVID and before fair housing, there was an issue with regard to rent regulations. And what happened was, first it was a question about deposits and advances, how much a landlord can hold as security. That is 1 month, and that's capped at 1 month, and that's in the aggregate. And then the DOS came out with an opinion that said landlords can't charge the tenant for rent, for the commissions. Landlords cannot charge tenants for the commissions. And the DOS came out with this opinion, and it kind of took everybody by surprise because traditionally landlords have looked to the tenant for paying those commissions. So NYSAR, as well as several other brokerages, filed a lawsuit challenging the DOS's opinion. One of the arguments saying that the DOS is not the one that interprets the law here. And number two, they got it wrong. So, and nowhere in the rent regulations does it discuss or reference the word commissions in the retention of these fees that are being charged. So a temporary restraining order was put into place. They have filed a complaint. An extension was provided from the Attorney General for an opportunity to answer. The answer just came back, I think, late last year. Oral arguments have not been scheduled, but while the temporary restraining order is in effect, the current rule is that a landlord can charge a tenant for the commissions in a transaction. And as it updates, I'll keep you posted. I'm sure NYSAR will keep you posted. But as it stands right now, that landlord can charge a tenant for the commissions in a transaction.
Okay, we have a question from Randolph Scott Peters. Can the landlord deny an applicant with bad credit even if the portion of the rent is being paid by a voucher?
If a portion of the rent is being paid by a voucher, then the credit score is relevant, and the landlord can deny the application based upon the poor credit score.
So I will let everybody know that this topic was discussed at great detail at the HDR Board of Directors meeting yesterday. And we are actually going to be putting together a program just on Section 8 questions, as well as other housing subsidy products that are out there. I think everybody has a heightened sense of awareness given the press conference that occurred this week about, I believe it's 80 some odd brokers and management companies and landlords who were cited in a lawsuit concerning discrimination on source of income. And obviously, given the fact that this is a great area of concern, we are going to be doing a program just on this topic alone. So please keep your eyes and ears open for that. I anticipate that will happen within the next month. And if we have no more questions for Brian, I'm going to turn it over to Mike and Ellie for our legislative update. Mike?
Thank you, Richard. And obviously, thank you, Brian, for all that insight. A lot of difficult questions and challenges before us, much of which is due to, unfortunately, the state legislature and New York state government and New York City government. And that trend continues. So it is extremely busy here in Albany. We're extremely busy here at NYSAR, trying to address a lot of issues before us. So with that, I'm just going to turn to my notes. Because if I don't speak from my notes, things can go awry. So it helps me stay on target. So New York state government is in the midst of budget season. When I used to work in the Assembly, we were at Assembly Ways. I was at Assembly Ways, the Ways and Means Committee, the fiscal side of the state Assembly, and this was the worst time of the year to be a staffer. Typically, it was 20-hour days for about 6 straight months as the legislature tried to get a budget done. At that time, you'll remember Governor Pataki was governor, and we would have budgets going and extending all the way until July and August, which was terrible. The good news now, though, is since Governor Cuomo's been in office, we've really been on target and gotten these budgets done by April 1st. So with regard to this year's budget, the state's facing a $15 billion budget gap as we head toward the beginning of the next state fiscal year, which begins in just about 2 weeks on April 1st. Thankfully for New York State government, Governor Cuomo and the legislature, President Biden approved Congress's latest round of COVID aid of $1.9 trillion, which is going to include $12.5 billion of direct aid to New York State government, as well as aid to local governments across New York State. Unfortunately, though, there remains an approximate $3 billion shortfall. Governor Cuomo has commented that it may still be necessary to impose some tax increases, and in fact, he's proposed several in his executive proposed budget. One is increasing the personal income tax rates on New Yorkers making $5 million or more, and that would be a temporary increase, slight increase. The second proposal he has is imposing a statewide tax on Airbnb and VRBO stays. Some municipalities already have those in law. The governor's proposal obviously would make that statewide. And then the governor also proposes the legalization and taxation of marijuana sales in New York State, and that's being negotiated right now between the legislature and the governor. Just this week, both houses of the legislature introduced their budget resolutions. What that means is essentially it's a description of their wish list and their priorities in budget negotiations as the parties get together and conduct those meetings. Both houses have proposed to raise an additional $8 billion, mostly by personal income tax rates on New Yorkers with adjusted gross incomes of $1 million or more. You've heard in the press advocates for housing, advocates for the poor, advocates for education, clamoring and making the argument that the quote wealthy need to pay more in taxes in New York to help us dig out of this global pandemic and some of the challenges that New York State faces. And the legislature has heard those arguments and in essence has agreed with them, and for the most part is going to be in their proposals increasing taxes on what it deems as the rich, which is really in their eyes anybody making an adjusted gross income of $1 million or more. Of note and real estate related, the Senate dropped its pied-à-terre proposal and does not include it in its resolution, while the Assembly does. The Senate has proposed to remove a New York State tax benefit for opportunity zones. So they decouple it from the federal tax benefits for opportunity zones. This is part and parcel of the continued fallout from the Amazon conversation that happened a couple of years ago. If you remember, Amazon was coming to Long Island City, Queens. The state legislature, and particularly the state Senate, raised a lot of concerns with that there would be millions of dollars of tax breaks going to large corporations, in particular, in this case, Amazon. That perspective continues in the New York State Senate, and in their eyes, they see opportunity zones as a benefit provided by President Trump to large corporations, when in their eyes, these corporations don't need those benefits. So in the Senate proposal, they decouple the state benefit from the federal tax benefit for opportunity zones and businesses within them. Both houses have proposed to increase New York State's capital gains tax by 1% if your adjusted gross income is above $1 million or more. On the positive side, there are no broad proposals to increase either the mortgage recording tax or real estate transfer tax. There is some support for small businesses in both houses' proposals, with a $100 million grant program, in particular in the state Senate proposal. There is a business income exclusion increase for small businesses and farms, and the Senate does include $500 million for commercial rent relief. So the Assembly and Senate proposals are remarkably similar. To me, it appears that they are united and proposing a united front as they go into negotiations with the governor and his team, and those negotiations have just begun. Again, the state budget is due to be completed by Thursday, April 1st. I expect that they will get there, although there could be quite a few bumps in the road going into it. But I think regardless, it's very clear that the legislature appears to be walking in lockstep with their desire to raise taxes on what they deem as high wealth New Yorkers, and they're going to try and do that in a variety of ways. Some of the broader issues that I think New York State government is facing, that NYSAR is facing, and the Hudson Gateway Association and its membership is facing, I'll go through several of those right now. The first of which is, I think, continued fallout from the Newsday investigation. Looking back towards, it's interesting to me, it's been less than 2 years, but it feels like about 10 years since Newsday released its fair housing investigation results in November of 2019. Immediately following that release by Newsday, the state Senate held a hearing in December of 2019, in which NYSAR testified at and agreed in large part with a lot of the concerns that were raised by the state Senate in its investigation and by Newsday in its investigation. Since then, obviously, the pandemic hit soon after that in early of 2020, and New York State government shifted its focus trying to address the needs of New Yorkers in the midst of that pandemic. You'll remember in 2020, we saw two initial proposals that Brian spoke to earlier today with regard to fair housing and the required fair housing notices. So while the pandemic certainly diverted the focus of the legislature, really since February 2020, state lawmakers are now once again beginning to focus its attention on fair housing legislation, and its reaction to not just the Newsday investigation, but its reaction to, I think, some of its findings in the state Senate's hearings subsequently to that Newsday investigation. So not surprisingly, we've seen at least 18 bills have been drafted and introduced by lawmakers, which represents their attempt in some way to address illegal discrimination in housing. Early in February, the state Senate February of this year, the state Senate passed a package of fair housing bills, several of which NYSAR supported. And while there were a couple also that NYSAR was and continues to be strongly opposed to. The legislation tries to address issues such as education. So there's a bill that adds 2 hours of continuing education on implicit bias education. There's another bill sponsored by Senator Skoufis that would add 30 hours of education in the broker's qualifying course and 2 hours of fair housing, 2 additional hours of fair housing in the salesperson's qualifying course, raising it from 4 hours to 6 hours. Senator Skoufis's bill also requires the Department of State to require that brokers have oversight instruction for brokers and salespersons in its education requirements. It also requires DOS approved educators to sign essentially an affidavit, an oath affirming as an educator that I will instruct to the prescribed instruction for that approved course by the Department of State. Other bills deal with fair housing testing. One of the, I think, hallmarks of the Newsday investigation was the fact that essentially people did not know they were being discriminated against until they saw the fair housing testing. So it was extremely powerful, in particular in the eyes of state lawmakers. So there are several proposals to provide more funding for fair housing testing, and in particular paired testing in New York State, one of which is a license fee increase bill. This is a bill that NYSAR supports. It would add $10 to a salesperson's license fee every 2 years and add $30 for a broker's license every 2 years. So while I think NYSAR's legislative steering committee, had a lengthy discussion on these bills, at the end of the day, I think they realized the importance of fair housing testing, as could be seen in the Newsday investigation. We're aware that it's probably the most effective way to combat illegal discrimination in housing. And those are some of the reasons why NYSAR is supportive of that proposal. Another revenue stream for paired testing and fair housing testing is a bill that would increase the maximum fine for a license law violation in New York State from $1,000 to $2,000. That delta, the additional $1,000 amount, would be dedicated towards paired testing and fair housing testing in New York State, and NYSAR is also supportive of that. Another issue the legislature is interested in drawing attention to is oversight, in its eyes, the lack of oversight in some cases by brokers over salespersons found in that investigation. So one thing the legislature has proposed to do is require 2 years of experience as an associate broker before an individual could be designated as an office manager. And that is also a bill that NYSAR supports. On the opposition side, probably the most onerous and offensive bill that we currently face is a bill by Senator Kavanaugh, chair of the Senate Housing Committee, that would require that an optional form be provided to your customers and clients, in which those customers and clients would provide demographic data, age, gender, ethnicity, race, things of that nature. And you would have to give this form to your customers and clients, and it would be optional for them to fill it out. But as you can imagine, our members, our realtor members making up our legislative steering committee, had a lot of concerns with that bill. Just on its face, we as an industry, I think, are being scrutinized right now, in particular in this investigation, for things related to treating people differently based on race and gender. And at the same time, now per this bill, we would have to ask the people that we're working with to provide us that information. It's been amended, I think positively, to make sure that it's an option for your customers and clients to fill out. But at the same time, I would argue that it's still awkward at best to be required to ask for that information. The second piece of the bill, which unfortunately has not been amended, requires real estate brokers to collect and disclose to the Department of State on an annual basis a tremendous amount of information with regard to the transaction itself. Offers that were made on the property, offers that were accepted, offers that were not accepted. What houses or apartments did you show a prospective client or your clients when you're representing them? Where were those apartments? Where were those homes? Things of that nature. So Senator Kavanaugh's bill, Senate Bill 2525, he's trying to collect a lot of data so some state agency, I guess, can do a deep dive and try and find out more about properties that are being shown in communities where there's activity or a lack thereof. From our perspective, it's really turning real estate professionals into data collection agents for the state, and we are strongly opposed to that bill. Also, let's be clear, the Department of State is not going to give an opinion on the bill because they don't as a state agency prior to its passage. But you can imagine the required service time that's going to be necessitated to deal with this type of legislation. In our estimation, the Department of State is nowhere going to be capable of collecting this data and somehow sifting through it and providing state government with any sort of analytical data. So we continue to be opposed to that bill. One last bill that I'll mention that NYSAR is neutral on is a bill by Senator Skoufis that essentially creates a standard operating procedure. If you've seen the Newsday investigation, you've seen the disparate treatment of individuals in those videos. They are extremely powerful. And I think it's troublesome to watch how certain races were treated so differently than, let's say, a white person walking into a brokerage. And in reaction to that, one of the additional bills that we face is a bill that would require all real estate brokerages to come up with a standard operating procedure that has to address at least these three things. Are you going to require identification of prospective clients? Are you going to require pre-qualification financing for clients or not? And are you going to require that the people that you work with sign an exclusive brokerage agreement with you? It doesn't have to be yes or no on those. It just has to be the consistent treatment of individuals. And you have to essentially certify that and send it to the Department of State per the bill. And NYSAR is neutral on that bill. One of the other additional things I want to talk to you this morning, or this afternoon, I should say, about is co-op transparency. We have been trying to raise the attention of this issue, this really, really important issue that NYSAR has been advocating for. Well, look, I've been with NYSAR almost 20 years now. It's been a fight that we've continued to have both at the city level and the state level in our advocacy efforts. My pitch to lawmakers, both at the city and state level right now, is we're in the midst of having this, I think, really important conversation about fair housing and illegal treatment of people in housing. And yet, for some reason, no one seems to be paying attention to a fair housing issue that we've been advocating for at least 20 years. So we're trying to continue to draw attention to this issue before state and city government. At the New York City level, it's an issue that the public advocate is currently in charge of. We are working with the public advocate staff. This is Jumani Williams, former city council member. Oddly enough, even as public advocate, you can still get bills through the New York City Council. So we're working with his staff to try and address, I think, some of the technical concerns they have with the bill, in particular, the remedy itself. At the state level, there are two different co-op proposals right now. One is a bill sponsored by Senator Kavanaugh and Assembly Member Chuck Levine that deals with a timeline and without consideration by a board, that application would be deemed approved after that timeline expires. There's a 45-day requirement and an additional 15 days given to the board if they require it. A second proposal by Senator Kavanaugh again, and a different assembly member, Nick Perry of Brooklyn, provides for a 90-day timeline. It requires a reason if there is a denial, and then again, if the board does not take action within that 90-day timeline, the sale is deemed, the co-op is deemed, or co-op sale, I should say, is deemed approved. What's really happening in the assembly right now in this conversation is they don't really have the ducks in a row, and they're not certain with which proposal they want to advocate for. So Housing Chair Steve Simberwitz, we've been in conversation with his staff and program and council staff in the assembly, really to advocate for the issue as a whole. They're trying to determine which way they're going to lean. Is it going to be Mr. Levine's bill, or are they going to try and push Mr. Perry's bill? So we're working the assembly on that side. Senator Kavanaugh, Richard Haggerty earlier on the call today mentioned the fair housing violation press conference, the source of income press conference that took place earlier this week. In that press conference, Senator Kavanaugh was one of the participants, and on that call, he was asked a question by Ellie Rodriguez, thank you, Ellie, about co-op transparency. And the senator reiterated his support very publicly for the two bills that he's sponsor of. So NYSAR quickly reached out to the senator's office and thanked him for that support. And we're trying to get a face-to-face or at least a Zoom meeting with the senator and his staff about the two co-op transparency bills that he's sponsor of. I can assure you, co-op transparency is once again going to be one of our top priorities on Lobby Day on April 27th. So look forward to that. Three, I'd say one of our other big issues we're faced right now as a state, and the legislature is not addressing it, unfortunately, is fallout from the Tenant Protection Act of 2019 and New York State rent regulations. So you'll remember there were dramatic changes in the rights and responsibilities of landlords and tenants back in 2019. And not surprisingly, they strongly favor the rights of tenants. This really is a reaction by the state Senate and state assembly to a generation of frustration of not being able to get the changes that tenants sought in their eyes. And in our eyes, I think these laws, the Tenant Protection Act of 2019, were not just far-reaching, but sometimes New York State government reacts and government just goes too far the other way. And I think that's what's happened here. NYSAR has been raising concerns with state lawmakers on the Tenant Protection Act, specifically around the challenges that we see with regard to security deposit limitations. Brian Levine spoke earlier today about some of those challenges and broker deposits. Some of the other challenges we've seen is really these security deposit limitations are, at the end of the day, I think in our eyes, doing harm to tenants, in particular with less than stellar credit. Remember, landlords used to be able to say, look, your credit's not great, but if you could just give me 1 month more security, so maybe 2 months security and then last month's security, I'll go ahead and rent the apartment to you. Well, landlords' hands are tied right now, and they can't do that per New York State law, per the Tenant Protection Act. So what are landlords doing? Well, they're saying, well, I'm sorry, I'm not going to take you as a tenant. Your credit doesn't meet exactly what we're looking for. So really tying their hands and not giving landlords maybe the flexibility they need, and in particular, harming some prospective tenants that have, again, less than stellar credit. Other concerns for us surround housing for college students, in particular students from other countries that might not even have a credit rating, a credit history. And these individuals had typically paid for their whole semester up front, when unfortunately, per the Tenant Protection Act, they are prohibited from doing that. There are other concerns that we've heard from some of our realtor members, in particular on the East End of Long Island, that have raised the issue of seasonal rentals and that those rentals are typically paid for in a lump sum amount. And again, you would be restricted from doing that under the Tenant Protection Act. So I bring these issues to your attention, but I want to bring you also back to political reality in New York State. I think while there is an understanding by some state lawmakers of the challenges that landlords are facing right now per the Tenant Protection Act, and I think in some cases are sympathetic to those concerns, I will be blunt with you and tell you that I think there's zero political will right now in Albany to open up the Tenant Protection Act to amendments and address some of these concerns that we have and other parties have about the Tenant Protection Act. Right now, I think there is zero appetite to do that. A couple other things on the political side of our work. So moving away from legislation and towards elections and politics, NYSAR and the Parkside Group and local realtor boards in New York City right now are engaged in a variety of New York City elections. There are at least 3 elections that are going to be happening in New York City races just this year, just in 2020. There are special elections happening next Tuesday for several New York City council races, and I think Eli Rodriguez is going to touch on these in just a moment. There will be primary elections for New York City offices, including mayor and New York City controller, and dozens of other New York City council seats that are going to take place in June. For the most part, these June primary races are in effect the race, right? Because these districts are so predominantly democratically controlled. The enrollment, I should say, the enrollment advantage by Democrats is so strong that the real race is only the primary, and those are going to take place in June. And I would suggest to you that's going to be the case for the New York City mayor and New York City controller's race this year. The general elections, I don't think there will be a viable Republican candidate for either of those offices. So, but once again, there will be general elections taking place in November as well. Let me just say that I think these elections are critical for realtors as they provide us and our association with the opportunity to have a voice and a say in who we think is best suited to hear some of the concerns that I've talked about today and others, and at a minimum, be cognizant of our interests and the general interests of the real estate community. I will tell you that not just New York City government, but New York State government, I think is tacking left even more. We're seeing more and more individuals being elected by the Working Families Party, and even left of the Working Families Party, Democratic Socialists and Democratic Socialist Party, individuals being backed by those parties and those interests. So I think it's critical that we as an association, both at the state level and the local board level, continue to be engaged in these elections. So we are working with New York City local boards, including the Hudson Gateway Association, and we're beginning the process of vetting candidates running for mayor and other offices. So there'll be a lot more to come, but in the meantime, I would suggest that you keep an eye out for Hudson Gateway Association updates on these races, NYSAR updates. I strongly encourage you to vote, and I also encourage you to support RPAC if you don't already, and I think we have other individuals who are going to speak to that later on. So with that, I think I'm going to hand it right over to Eli Rodriguez. So Eli, before you start, let me just say one thing. This is off the cuff. I want the people on the call to know what I think a tremendous resource Eli Rodriguez is going to be to the Hudson Gateway Association of Realtors. I've been fortunate to be able to work with Eli throughout his tenure with the Bronx Association. His knowledge of New York City and the Bronx in particular, his relationships, I think, with those communities are going to provide a tremendous benefit to the Hudson Gateway Association and its overall membership as well. So Eli, I turn it over to you.
Ellie, you are muted.
You're muted, Eli.
There you go. Can you hear me now?
Yes.
Thank you, Mike Kelly, for those wonderful words, and thank you, Brian Levine and Brian Phillips. Thank you for putting this program together. As Mike Kelly mentioned, this year is going to be an important political year. As you may know, by the end of this year, we will have 30 council members. I am going to talk about two special elections being held in the Bronx on March 23rd. One election will take place in District 11 and the other in District 15. Now, whoever wins the March 23rd special elections will serve until December 31st of this year. And after that, future representation will likely be determined by a June 2021 primary and a November 2021 election. In District 11, Councilman Cohen resigned from the city council seat on December 31st when he was elected as a judge to the Bronx Supreme Court in November. He was term limited anyway. District 11, if you don't know, encompasses Kingsbridge, Norwood, Van Cortlandt Village, Wakefield, Riverdale, Woodlawn Heights, and part of Bedford Park. Currently, there are 6 candidates that are running for the seat. The top 3, from what I've gathered, is Eric Dinowitz, Jessica Haller, and Daniel Paternek. Now, Eric Dinowitz is the candidate with the most name recognition and considered to be the lead. He is the son of Assemblyman Jeffrey Dinowitz. Jeffrey Dinowitz over the years has been a friend to the real estate trade. Eric is a teacher and a Democratic male district leader for the 81st Assembly District. He has secured most of the union's support, and obviously he will benefit from his father's long political ties. He was thought to be more moderate, but he is leaning more to the progressive side. And although recently he stated that he's in favor of commercial rent control, I believe that we can work with Eric. His opponents obviously claim that he's part of the Democratic Party machine. The other 2 top candidates, Jessica Haller, she's an environmentalist and a tech entrepreneur. And the other is Daniel Paternek. He's a lawyer from the Bronx, and he serves on Committee Board 8 on the Traffic and Transportation Committee. He's the chair of that. Now, regarding financing, the last time the contribution filing in a special election race were, I guess, tallied, the New York City Campaign Finance Board had Haller leads in the contribution with $79,000, followed by Dinowitz at a close second with $72,000, and Paternek about $30,000 behind with $42,446 raised. Although Eric, I think that we need to sit down and have more conversations with him. We have a few members that are close to him, but I think he is the candidate that's most likely to be a friend to our trade. In District 15, Councilman Richie Torres resigned his seat when he was elected to the Congress in November of 2020. District 15 encompasses the area of Bedford Park, Fordham, Mount Hope, Bathgate, Belmont, East Tremont, West Farms, Van Ness, Allerton, and Oldenville. There are about 9 candidates running for that seat. The top 3, from what I've gathered, is Johnny Sanchez, who's a district manager for Bronx Community Board number 6, Ichia Bravo, who's a district manager for Bronx Community Board 7, and Alyssa Crespo, and she's an education, or was the education liaison at the Bronx Board President's Office. Ms. Bravo has secured a lot of union support. The question is whether they're going to lend some troops on the ground to get her elected. She's got some folks on the progressive side that have endorsed her campaign. Among them, Alexandra Biaggi, and she also has the support of the Bronx Board President, Ruben Diaz. Now, with HGAR, we've been meeting with the candidates, and we we had a meeting set up with Ichia, and she canceled the night before. And we've been trying to meet with her since, and we haven't had any luck. So we'll continue to reach out, hoping to have a sit down and meet and greet with her so we can talk about what some of our issues are, because there's a few coming up that are important, and we need our future elected officials to know where we stand. Johnny Sanchez. Now, we did get a chance to meet with Johnny Sanchez, and we met with him for about 45 minutes. He's a graduate from New York University. Prior to becoming a district manager for Community Board 6, John served as a deputy chief of staff in the state assembly. Now, John has been very active in bringing resources to his community. He was involved in getting them a $200,000 grant for the Bronx small businesses to improve their storefronts. He's a moderate. However, he's very understanding of our issues, because he used to be a real estate agent, and which was encouraging to us. And he supports, or his view are similar to what we need right now in the city council. As I mentioned, we're going to have a lot of seats that are going to be vacant, and we need some folks that at least listen to what we have to say. Those are the two top candidates in District 15. Now, in terms of campaign contribution raised to date, according to the Campaign Finance Board, Sanchez leads the field by over $20,000. And Ichia Bravo is second. Crespo is second, and Ichia Bravo comes in third. Out of the three candidates, John Sanchez gives our industry the most hope of pushing some of the issues that are relevant to our trade. And this is the first election with ranked voting, and from what I hear in District 15, the votes are dismal at this point. So we're looking for a greater turnout in support of the candidates that are going to push for what's important to our trade. Now, these two special elections are important because you have to consider that Councilman Mark Jonai, who was a moderate and a dear friend to the trade and himself a realtor, decided not to run and retire at the end of this term. And that was a blow to us. Mark is a person that we could pick up the phone and call, and he was very responsive, and he was the voice of reason in the city council. But so we hate to see him go. So it's important that we elect candidates that are going to at least sit down and meet with us. We want candidates who are in favor or welcome participatory legislation. We want to be able to have a conversation with the council members when ideas pop up, so we can give them input as opposed to trying to defend something that they've already come across, and we have to try to talk them out of it. And also, Councilman Cabrera, who's from District 14, a dear friend to our trade as well, he's term limited. So, however, he's running for the Bronx Ball president. So that's another seat that we have to be concerned about, that we try to support those that are favor our industry and less on the progressive side. And I can't stress enough the importance of going out to vote for candidates that share our views. In 2021, there's going to be discussions about several bills that are going to be detrimental to the real estate industry. One of them is if a owner of a building wants to sell, he has to offer that building first to a nonprofit, and that nonprofit then has 120 days to secure funding and get the paperwork together before the owner can offer that to the private sector. And that's sort of, it doesn't promote public and private partnership. It favors one over the other, and that's a critical bill. And the other is a bill that will prevent realtors or during the rental process, anywhere along the rental process, for inquiring about a background check. So those are two concerns of ours, and those are the bills that are that's being floated around and picking up some momentum. So it's important that we support those candidates that would at least sit down and talk to us. So anyway, that's my 2 cents worth. Mike, you have anything to add?
No, I guess on the city council bills, I want the folks on the call to know that, in particular on the criminal background check bill, Ellie, that we've had multiple conversations with city council members from boroughs across the city, raising some of the concerns that we have. There are similar bills to this in law in, I think, 9 major cities across the country, including San Francisco, Minneapolis, Detroit, Seattle. But none of those bills go so far as to completely ban the use of criminal background checks by licensees or property owners, landlords. So in our eyes, look, the advocate's perspective is people that have served time, that have held up their end of the deal and served their prison sentence should not face the type of housing challenges that they're currently facing when they get out of prison. I think it's hard to argue that these individuals aren't facing a lot of housing challenges. And then they go into, I think, the homeless shelter system, and they don't want to be there. Again, from their eyes, they've served their time, and they want to find an apartment to live in. I think with that, we get that, and I don't think our concern is restriction on the ability of individuals that have served minor crimes or misdemeanors, right, or white collar crimes, things of that nature. But I think the concern from us is this bill goes so far as to prohibit the ability of our members and landlords to find out if a convicted murderer is going to be renting the apartment next to, my mom and dad, for example, right, or a sex offender. Right? There are a lot of look. I think I understand where the sponsor is going. This is Councilmember Levin. We had a meeting with him a week ago with some of our realtor members about the bill. We raised these concerns. The problem is, Ellie notes, though, that these are real issues, and that's a bill that has 21 other sponsors in the city council, and that number probably will grow. So the council is sympathetic to this issue. The mayor has already expressed support for it. Public advocate Jumaane Williams has expressed support for it. I think we'd be supportive if it just didn't go so far as to a complete ban about the criminal background check. So it's definitely one we continue to be engaged on.
Mm-hmm. I just want to add that the city council recognizes the need for background checks because they carved out 2 exceptions. One, if you're a homeowner and you wish to rent a room to someone, you are then allowed to do a criminal background check. And at NYCHA and federal funded programs, they're allowed to continue doing their checks that they require before they allow someone to be a tenant. Anyway, thank you so much for the time.
Okay, so I think it's time now for Anthony to share with us, once he unmutes, about RPAC.
Thank you, Mike. Thank you, Ellie. That was very informative. As you can all tell, our industry is under constant threat. So it's important that we do our part to invest in RPAC each year. While you probably heard of RPAC, and some of you may, some of you might not have, what RPAC actually is. RPAC is your line of defense in the industry. RPAC is, our mission is to protect you, your business, and your clients. And as a realtor, you need someone to safeguard or guard your business against threats that you can't see coming. Please join us as we make our voices heard, so they are heard by lawmakers whose decisions affect our industry and our livelihood. We raise money through RPAC to support candidates who support real estate in every state and on the Capitol Hill. Please don't wait. Invest today. RPAC is not a Republican party. It's not the Democratic Party. It's your realtor party. On issue after issue for the past 50 years, RPAC advanced the realtor point of view, and together we build a strong foundation for the future. It's no wonder we are the #1 PAC, or the PAC in America. We owe that distinction because of our passion for our profession, our clients, and for our communities. I'm going to post a link in the chat for you to make a contribution. Please visit our RPAC Facebook page or on the AGAR website to make a contribution. You will need your NERDS number to register. It doesn't matter how you invest. Just make sure you do it so RPAC can protect your tomorrow today because that's who we are.
Very good.
Very informative discussion. Thank you all for all who stuck with us and attended the register and attended. And thank you to all my fellow co-hosts and our speakers. Until next time.
Have a good day, guys. Thank you much.